everybody. How are you? We've got, good, I'm glad to hear that. We've got with us today Justice Elena Kagan. Justice Kagan went to Princeton for college, then went to Oxford, and went to this law school where she and I knew each other. We were a class apart. She then went to clerk for Judge Mikva on the DC Circuit, Justice Marshall on the Supreme Court, spent a couple of years at a law firm, and then went to teach at the University of Chicago. From there, she was recruited by President Clinton to be associate counsel to the president, and then deputy director of the Domestic Policy Council, after which she returned to Harvard Law School, became a professor, became the dean, and she was did a lot of stuff, including she was the person who designed, built this building that you're sitting in now.
Every stone.
And created, how many of you have had Leg Reg yet? She's ran the curricular reform that produced Leg Reg and the first year international comparative law course and problem-solving workshop. She created coffee. Well, she didn't create coffee. She put out coffee and hot chocolate, and made the place a lot more user-friendly. And so we have a lot to be thankful for, including the fact that she's returned today and agreed to answer questions. Now, I will have the prerogative of asking the first few questions here, and at the end, we'll reserve a little bit of time for students to ask some questions if they like. And so, shall we begin?
Can I just say I'm glad to be here?
Yes, of course.
Okay. It was a very impressive recitation of my CV. So thanks for remembering all that. But I always love coming back here. You know, I love this place. I loved it when I was a student. I loved it even more, if that's possible, when I was a faculty member and then the dean. And it's really a special time for me to come back to, John, because you're the new dean. And we have gone back, as you say, a long way, and we've been great friends for decades now. And it's thrilling to me, as it was with Martha as well, Martha Minow as well, to have somebody who I so love and admire in this job. So you're going to do a fantastic job. I know everybody's really excited to see the great new Manning deanship, and it's really a thrill to be here for it.
Thank you very much. I really appreciate that. It's very kind of you. Now.
You look embarrassed.
It was very nice. It was very nice. So may I start with asking you a question that I've always sort of wondered about, and I bet a lot of other people wonder about, but I bet you don't get asked a lot. So what's the most fun thing about being a Supreme Court justice?
It's a pretty good gig. So I'm not sure I can pick just one. I mean, the whole thing is pretty. I thank my lucky stars that I'm in the position that I am. I mean, a lot of the times it feels like a real responsibility. It feels pretty serious. It feels pretty awesome in the sense of the word of like, gosh, this is supposed to fill you with a sense of awe and responsibility that you're in a position where you can make a difference. But it's also just, as you say, just a heck of a lot of fun every day. I love thinking about law. I love thinking about really hard legal issues. I love reading and writing about law. And if you love all those things, it's kind of the dream job. I've been very lucky in all my career, and I've had lots of jobs that I've liked, and loved. But it's a special thing to come into that building every morning, and which is very majestic and fills you with a lot of awe. And And to realize that you've been given this responsibility, and also to just find it so damn much fun. Thinking about these really super hard questions and trying to figure them out and trying to get to the right answer and talking to my colleagues about them and talking to my clerks about them. And, what's to complain about?
Sounds right to me. So on the subject of your colleagues, one of the things that I've observed over the years is, you all sometimes disagree with one another.
Every once in a while.
Every once in a while.
Less than some people think. The laughter out there suggests that people think we're at each other's throats all the time. And in fact, that's not true. About 50% of our cases, maybe sometimes even a little bit more, are decided unanimously, which is a kind of amazing thing because these are hard cases. They're by definition cases that other courts have split on and not been able to come to a single right answer on. And notwithstanding that they're hard and have caused these disagreements in the lower courts, half the time, 8 or 9, we've been 8 for a couple of years, but usually we're 9, very opinionated people are able to come together and decide what the right answer is unanimously.
So what does that say about the lower courts? Never mind.
I think what it says is these are hard questions, but we're able to reason together, and we're able to persuade each other, and we're able very often to find the single best outcome to cases. But about, the other 50% we don't. Now, a lot of those are pretty lopsided decisions. They're 8-1s, they're 7-2s, or they're 5-4s, but very much along sort of strange and idiosyncratic lines. So I think when people think of disagreement on the court, they're thinking about those kind of 5-4 decisions where you can sort of predict who's on one side and who's on the other. And I would say that that's only about 10% of what we do. Now, it's an important 10%, so I wouldn't at all deny that. But we do agree with each other a lot more than we disagree.
So even though on those 10% of the cases that you disagree, and sometimes you disagree sharply with one another, my impression is that you all get along extremely well personally. You're friends, you respect one another. Could you talk a little bit about that, how you make that work?
Yeah, well, we do. We get along pretty well. I think we all think that everybody on the court is attacking every case, every issue in complete good faith and is trying his or her hardest to get to the right answer. And, we know that we're not going to agree on some things. We have methodological differences in how we approach certain issues, and we have differences about just the meaning of certain provisions, whether it's constitutional or statutory. But I think we give each other a lot of credit for coming at it, every case, every issue, every problem, with good faith, with the real effort to get it right. And in a way, I think we understand each other and what each other is doing better than anybody else in the world does. I mean, we're this small institution. There are only 9 of us who understand sort of the ins and outs of what it's like to do the job every day. And that gives you a real understanding of your colleagues that isn't shared by the rest of the world. So it's true that sometimes we write these opinions and it's like we're hurling invective at each other. It looks as though we're about to slit each other's throats. But all of us know that there's a next day and a next day and a next day, a next case and a next case and a next case. And that your old boss, Justice Scalia, had a saying, which, gosh, I heard him say 50 times. He said, if you take it personally, you're in the wrong line of business. And I think that we all understand that. And we all understand that we're trying to the best of our abilities to do an extremely difficult job, and we give each other credit for doing that, even when we disagree with each other. It doesn't mean, I don't mean to be Pollyannish about this. I mean, there are times when I'm annoyed at some things that my colleagues do and say. But number one, it's not good long-term strategy to stay annoyed. But number two, beyond the kind of strategic, there's a next case and there's a next case, I think I just give them all a lot of credit for working hard and trying to get things right. And if we don't disagree today, I'm hopeful that if we do disagree today, I'm hopeful that we won't tomorrow. And and also I just like them all.
Okay, that's very good. I'm glad to hear that. Could I ask you a couple of questions about the process of decision making and the way you think about your decisions? So I'd like to start at oral argument. So a lot of the people in this room in the spring will give oral arguments in their Ames moot courts, in their 1L Ames, and then others will give upper-level moot court arguments in various moot courts. And so here's my question. Does oral argument matter? Does it change the way you and your colleagues think about it? How do you think of the purpose of oral argument, and what's the most effective kind of oral argument you hear?
Well, I think oral argument does matter, although it's not the thing that matters most. So if you're going to choose between having a great brief and making a great oral argument, you should always choose to write the great brief. That's where the justices really learn about a case, that in the course of reading briefs, that's when you're really thinking through the issues the most. And by the time you read the briefs, you probably have some idea of which way you think the outcome should go. Now, it doesn't mean that you're sure of that. And so when I walk into oral argument all the time, I have a thing, I'm leaning this way. Maybe sometimes the lean is very pronounced. Maybe sometimes the lean is just slight. But there is a lean that the briefs create. And then the question is, does the oral argument do anything to make me reverse direction? And I wouldn't say that it very often happens that I'll reverse direction, but there are definitely times when oral argument makes me think about certain kinds of arguments in a different way. Oral argument raises questions in my mind that I hadn't thought of before. Or very occasionally, oral argument, just that hour itself, will sort of, swing me over to the other side. More often, I think oral argument makes me just think about different questions and issues, and makes me come back to my chambers to talk to my clerks and to talk to my colleagues about a new set of things. So I think it matters, even though I wouldn't say that it often flips me all the way from one side to the other. But the other thing that we use oral argument for, if you come to the court, you see that we're asking the lawyers a lot of questions, and we care about what the lawyers say. But sometimes, honestly, the questions are more in the form of statements. It's like you just sort of say how you think the case should come out, and then you somehow manage to put a question mark on the end of it. And I think what that is about is much more talking to your colleagues than actually asking the lawyers to answer questions that you genuinely want to know the answers to. Because the way the
I've
court
always
works,
suspected that, by the way.
Yeah, well, it's not a big secret, so it's not a state secret that I'm letting on here. I think you just have to come to a couple of oral arguments, and you've done a couple of, more than a couple of oral arguments, so you know this. The way the court works is the first time we're really talking about a case to each other is when we meet for oral argument. That's not true of every court. So, for example, the Canadian Supreme Court, they actually meet as a conference, and they talk about a case before they go to oral argument. But for us, oral argument is the first time. And the next time is going to be the time when we actually, even if just preliminarily, decide something. And what happens after oral argument is that we'll go to conference, and the Chief Justice will start, and he'll say, you remember that the issues in this case are the following, and then he'll say how he thinks those issues ought to be resolved, and he'll vote. I mean, that's not a cast iron vote, but it's at least a preliminary vote. And then it will go around the table in seniority order. So until a few months ago, I was always the last person to speak. And if you're the last person to speak and everybody has voted by the time it gets to you, well, you're looking for another forum at which to try to convince people. You know, it's possible that even as the last person to speak, then everybody's voted, you'll say something so brilliant that everybody will say, oh, I want to switch my vote. But honestly, it's not likely. And the better time to try to get some ideas into your colleague's head, and I think that this is certainly true for the people who speak near the end at conference, but even for the people who speak near the beginning, a very good time to get your colleagues thinking about things and to try to get your colleagues to see a case the way you see a case is by asking questions that tip off your colleagues as to which way you're leaning and why. So sometimes the poor lawyer is sitting there and we're throwing these supposed questions at the lawyer, but everybody knows that we don't really care what the lawyer is going to say in response. The lawyer is just kind of the medium for talking to somebody on the bench.
Thank you. So now oral argument is done. You've had conference. The case is the preliminary vote is decided. You're assigned the opinion to write. So how do you go about writing your opinion? And I want to ask a very specific question about this. Your opinions are very distinctive, right? You can always tell a Kagan opinion. They're very conversational. It sounds as if you're trying to explain the issue to a friend who may or may not be a lawyer, right? Or who's a lawyer but may not be very, very steeped in the case. So is that a style that you developed as a justice? Was that the way you wrote before? If it's the way you developed as a justice, what's important about writing that way? Who's your audience?
Well, I try to make it conversational, but not completely informal. I try to have some sense of the importance of this kind of what we're doing, and that these opinions are a kind of formal work product of the court as a whole. So especially when I'm writing majorities, when I'm writing dissents or separate opinions, it's a little bit different because then I'm speaking more for myself. But especially when I'm writing majorities, I'm speaking for the court, and I think that suggests that you should speak not completely informally. But I do try to make myself clear, and I guess beyond clarity, I think you're right in saying that there's a certain way in which I write opinions. You said conversationally, and I think that that's actually the answer to your question, because what I really do when I write an opinion is I think about it the way I used to think about preparing for a class. And what I used to do when I prepared for a class was just to come into my office that morning and to sit there and sort of say, here's how I want to explain things, in what order, and to think about the audience. And the audience is a set of really smart people, really eager to learn people, but not necessarily people who know a lot about the subject matter going in. So you're trying to figure out how to convey things, and that's in part through understandable language. It's in part through using analogies or examples that stick in people's heads and make them see things a certain way. And so I was very used to doing that from my days as a teacher. And I would say that when I sit down to write an opinion, that's what I'm thinking about. Like, how would I explain this to a class of law students or even a class of first-year law students who don't know a whole lot of law yet, but want to learn it and are really smart and really engaged and will figure it out if you help them some. And so I think that's the way I try to write.
So does this take a lot of work? I mean, it seems, the writing has an effortless feel to it, Does it take a lot of effort to do that?
It takes a ton of work. I mean, what you want to, if it has an effortless feel to it, that's great. That's almost the best compliment you can give me. This goes back to a baseball player for a long time ago. Probably none of these people will know, but Joe DiMaggio was always known as a baseball player who made really super hard things look completely effortless. And boy, I would love to think that seems to me a very high quality, high compliment indeed. But in fact, it takes a ton of work. I mean, I think almost everybody. There might be these genius writers in the world who can sit down and write a first draft, and it's just everything that anybody would want. But I don't know many people like that. I think I've met 2 or 3 in the course of my entire life. Mostly, I think writing is really hard.
So you could do a lot of drafts.
I do a lot of drafts. I stare at the same paragraph for hours at a time. I can stare at the same sentence for hours at a time. It takes work. It takes time, and you have to be willing to devote it to, in the end, get a final product that looks as though it's all just flowed from your pen.
Okay, so here's another question about writing opinions, but it's about a particular kind of opinion. And so you and your colleagues write dissents. Who are those for? Are they for the other justices?
I try to win all the time so that I don't have to.
And so on the rare occasion when you have to write a dissent, who are you writing for? Is it to try to persuade the other justices? Is it to lay down a marker for the future? Is it sometimes for Congress? Is it for the public? Is it for law students?
I think it really varies. So I don't have a single answer to that question. I think sometimes you are unfortunately in the position of dissenting in a case which you think is extremely important for the future of the law, for the future of the country. And if you think that the court has gone terribly wrong, then you're writing for posterity in a way. You're writing for the next generation or the next time that the issue comes around, in the hope that the court will see it differently. So there are definitely cases where I sit there and I think about, the court's gone wrong now, but this won't be the last time that the court faces this issue or an issue very much like it. And I hope the court will reach a different result in that case, and that's who I'm writing for, a future court. But there are lots of dissents that you write where actually you don't, number one, it's not that important, and number two, you don't have any expectation that there will come another time and an opportunity to revisit the ruling. And then I think you might be writing for law students, as you said, to give them a different sense of how the law should operate, and to make them think not only about that question, but about other questions in a way that you think is better than the one that the majority has chosen. You might be writing, it might not even rise to that level of importance. It might just be 2 people look at a case and they just see the answer differently, and nothing terrible. There's no great methodological difference. There's no difference that matters for the future of the country or the future of the law. It's just you look at a problem and you see the matter differently, and the parties deserve to know that it wasn't a 9-0 slam dunk, that there was another way of viewing this that some people thought was the better one.
So it's just your job. It's your job to say how you decide the case.
Yeah, I mean, sometimes it's just that simple.
Yeah, interesting. So do you have a favorite opinion?
I don't think I have a favorite opinion. I guess I try not to think about that. I try my hardest every time out. And whether I think I've written some opinions that I think are probably going to be important in the evolution of a certain area of law, and I've written lots of opinions which I think are not terribly important, and I try to approach them the same, actually, and I try to pay almost as much attention to the one as to the other, and to sort of grade it in my head in the same way. And by the time I circulate them, by the time they're out, they've all passed some threshold in my mind. And I guess I just try to do the best I can with everyone, and then go on to the next one without thinking too much about favorites.
Okay. So I have one more question that's specifically about the court, and it's a little bit off the path that we've been on so far. So a BU professor used to go and count the number of laughs on the transcripts.
Yeah.
And so...
Right, the transcripts, they come out, and they actually say when somebody, whether a justice or a lawyer, has provoked laughter.
Right.
It will say, Justice XYZ, and then there will be a question, and then it will be a bracket, laughter. Right.
So Justice Scalia used to be the person who got the most laughs.
Yeah.
Who do you predict will be the funniest justice going forward?
That's not hard. I mean, we've had almost 2 years, unfortunately, since Justice Scalia died, and it's Justice Breyer going away. So Justice Breyer and Justice Scalia get laughs in different kinds of ways. Humor is a funny thing. Justice Scalia got laughs because he was incredibly sharp-witted, a little bit acerbic. But he would interject these just single sentences that made everybody kind of crack up. Justice Breyer gets laughs because he devises these long, complicated, kind of crazy hypotheticals. So however, all of you are first years, and you're going to hear a lot of your law professors do.
You realize, by the way, this is going on YouTube, right?
I don't think I'm telling Justice Breyer anything he doesn't know. You'll see a lot of your law professors do these kind of crazy hypotheticals. Well, I would just say that none of them hold a candle to Justice Breyer in this respect. But so Justice Breyer is pretty much going away with the title. But I will say, there was, in my early years on the court, the guy who did this, Jay Alexander, right, at Boston University, said several times that I was underperforming. That he thought I was funnier than I was appearing in the courtroom, and I think I've been doing a little bit better these last few years. So after Justice Breyer, I think if somebody told me, it's not like I pay attention to these things, but one of my clerks told me that the Chief Justice and I were in a pretty good race throughout the year for second place. So
very, very nice. Okay, so may I shift to...
But second place is way off the lead.
Is that right?
Yeah, Justice Breyer going away. He's lapped the field.
Wow.
Yeah.
There you go. All right. I don't remember that, but I believe you. So could I ask you a couple of questions about legal education?
Sure. I once thought about that.
So the main question I have for you is, how did your legal education, how did your education here at Harvard Law School shape your career and the way you think about law?
Well, I think for most law students at most law schools, your first year experience is probably the most important, because it really, nothing that you learn in law school about specific subject areas, I have to say, is all that important, because the law changes, and what you learn as a first year probably won't be the same as the law when you next encounter it.
But still very important to learn it.
Yeah. But you can only learn what I think is truly important, which is learning to think like a lawyer, by learning substantive law, right? But what will stick with you in the sense that you'll remember it 20 years down the road, and it will actually be relevant 20 years down the road, is less the ins and outs of particular legal rules and much more just the process of, I believe that this thinking like a lawyer thing is a real thing. And it's very hard to describe and to define, but you know it when you see it. I used to, when I was at the White House, there were several years when I was not in a lawyer's role, when I was instead in a policy role. And during that time, I used to have meetings all the time with lots of people from different agencies, from different parts of the government, where we would try to put our heads together about a particular issue and come up with the best policy and come up with some kind of plan for how to achieve it. And all the time, I felt as though you could pick out the lawyers in the room, just by the way they thought, by the way they approached problems, by a kind of systematic nature of their thought, by a sort of by analytical skills that I don't want to make too broad generalizations, but that for the most part the non-lawyers didn't have. And so other people bring different skills to the table, for sure. It's not like the lawyers are the only ones making a contribution in the room. But I think that there's a huge contribution that people with law degrees make, whether they're acting as lawyers or they're not acting as lawyers, just by the way they think, by the analytical skills that they've developed, by the way that they've learned to approach legal problems, by a sort of systemization and organization in their own thought that really comes from the first year of law school. So I think that that's the biggest thing.
So there are a lot of people here who are in their first year of law school, and you and I have been in the business, more than 3 decades. And so I wonder if you could talk to the folks who are just starting out about another aspect of being in the law, being in the world as long as you and I have, which is...
You're making us sound very old.
I feel pretty good, actually. What professional disappointments have you had along the way, and how have those shaped you, and how do you think about them now, looking back over sort of 3 decades of being a lawyer?
Well, I prefer not to dwell on them all that much. I've had lots of professional disappointments along the way, starting from when I was in law school, actually. So does law student days count as a professional?
I think it counts, yes.
So when I was these people's age, I got to law school. I actually, I was pretty confident, actually. I wasn't one of these people that was totally scared of the whole experience. And I did terribly, actually, my first semester of law school. So I think that this is a lot of, I haven't tried to keep this a secret, so there are a lot of law professors who use me as an example of this. But I was like, bottom third of my class, my first semester of law school. So that was a little bit of a shock to me, and surely a disappointment. And so I just had to figure out what I was doing wrong, and I guess it seemed...
How did you do that?
Yeah, well, you don't want the ins and outs of it, but it took me a few days to kind of get back on the horse. But then I did get back on the horse, and I talked to a lot of people about how to improve my performance and what they thought I was doing wrong, and I tried to reach out to a lot of people to get advice, and I worked really hard. I didn't give up, which some people might have done, I suppose, but I didn't. I sort of took it as a challenge, and I think that was a pretty good thing to do because
worked out pretty well. Yeah,
it was okay the rest of the way.
Yeah.
But so I think that sometimes disappointments like that are just like the lesson of them is. You have to shake it off and just keep working and try to figure out what you did wrong and how you can make it better. But I think sometimes disappointments are even sort of opportunities in disguise. There are lots of times, I mean really lots of times in my life where I haven't gotten something, and then it turned out that some years down the road I looked back and I thought, you know, it was kind of better that I didn't get that I didn't get that thing, because instead I got something else that I never would have gotten if I had gotten. So you know, there are lots of things where I've thought I wanted jobs and didn't get them. I mean, for one, I was nominated to be a D.C. Circuit judge, and it was during a time when there was a lot of political conflict. Like, when is that not the case these days? And never got a hearing, and never got a vote, and never became a D.C. Circuit judge. And I was very disappointed at the time. Yeah, it's a good disappointment to have. It's kind of a high-class disappointment. But then it turned out, you know, I became dean of Harvard Law School, and that was a huge amount of fun. And
seems like a good job. Yes.
Yeah, it was. Don't worry, John, you're in a good job. And you know, so I think things like that happen all the time. When one door slams shut, and you think, oh my gosh, you know, what's going to happen to me now? It turns out that a window opens someplace down the line. So that seems sort of cliche-ish, but I've decided in life that it's true.
A lot of cliches become cliches because of that.
They're
yes.
true, exactly.
Okay, so while we're on the subject of your being a Harvard law professor and, you know, Harvard dean, so you taught civil procedure, you taught administrative law. Those are big courses. You used the Socratic method. You cold called people, yes?
Yes.
So would you explain why you thought that was a good way of doing it? And then my question is do you approach oral argument in a similar way to the way you approach the questions that you ask your students?
Well, I cold people all the time. In fact, my class is people didn't even volunteer all that much just the way I ran it. It was like you were on a train, and the train was like me calling on somebody, and then me calling on somebody else, and then me calling on somebody else, and that's the way we did things. And then we got to the end of the class, and presumably you would learn something. So, why did I do it that way? I think a lot of different reasons. I think every teacher has their own style, depending on what works for that teacher and what makes teaching fun for that person. For me, listening to myself lecture is totally boring, so I would never do that. And because you know what you want to say, and you've already thought those thoughts, so there's nothing really very interesting in just sort of like reading back something that you've already written or something. And then as between volunteering and cold calling, taking volunteers and cold calling, I guess I think students should learn to respond to questions, that it's not a skill that every lawyer is going to use every day, but that whether you're a litigator or whether you're some other kind of lawyer or whether you're not a lawyer at all, that kind of ability to come back at people when they ask you a question and to be quick and to be confident, which I think is what the first year cold calling experience does for people. It teaches them a certain kind of confidence in their ability to speak on their feet and think on their feet. I think that those are good skills to have. And I think that other people in the class learn a lot too from the sort of back and forth that Socratic cold calling gets, because you can imagine yourself, even if you're not the person being called on. I think that what that does is you imagine yourself being called on. What would I say to that question? And so you're constantly thinking in a class because you're trying to figure out what is the answer to that question that she's posing to my neighbor. And so class becomes a lot less passive, A lot less I'm just taking notes, and eventually I'll get around to reading those notes and taking an exam. But it becomes a much more active, engaged endeavor.
Thank you. Here's my last question, and then we'll take a couple of questions from the audience. So my last question for you is, looking back from today to your first week of law school, what do you know now that you wish you had known then?
I don't know. That's too hard. I'm going to reshape the question.
Okay.
I presume that these are almost all first years, right?
Lots of them are
So
first years, yes.
I'll just give you a little bit of advice. All right?
That's a good one. I'll take that as a friendly amendment, yes.
That's basically what you're asking me to do, right? Give them a little bit of advice?
Yes.
So here's my advice for you. This is just, first off, sort of like appreciate the fact that you're here. It's a great place. You have great faculty. You have great colleagues. And you can learn from all of them. And that's a kind of wonderful opportunity that you've been given. So get to know some professors. If that means knocking on doors, go knock on doors. Get to know some people outside of the classroom. Take the classroom experience seriously. Get engaged in it. The more you, I think that the less passive you are in class and in general as to your legal education, the more you get out of it, the more you learn what it means to think like a lawyer, what it means to speak like a lawyer. So if it's scary to you at first, just get over that fear. Try to jump in. Try to start learning all these things that people are throwing at you. Recognize that your peers are fantastic. For the most, I always, when I went out to lunches and things like that with Harvard Law students when I was a dean, I would say, well, what surprised you most? And the answer was always the same. They would say, the people are very nice, meaning the other students are very nice, as if, of course, I'm a nice person, but I expected all my classmates to be cutthroats, right? And in fact, people here are pretty nice, and they want the best for each other, and you can. So that means you don't have to worry about being embarrassed in front of them when you volunteer or when you're cold called or whatever, because they know that they'll be in the same position tomorrow, and nobody's making any judgments, and nobody's everybody's rooting for you, and you can really learn from each other. So that's the other thing, is that. And I don't mean just learn like go study together or something like that. Because part of what you're doing here is obviously studying and learning, but there's a way in which this group of people, there's so many interesting people and so many unbelievable experiences, and I always used to tell people when I was dean, don't spend your whole first year with your nose in a book, actually. Take that seriously, but go out with people and meet people and get to know people, and they're going to be your friends for life. And still, when I think about my best friends, and an enormous percentage of them come from my 3 years at Harvard, and so be social as well as taking all the work seriously. And I think that's it. What did you tell them yesterday?
It wasn't 100% dissimilar, actually. I told them to, talk to one another, argue with one another. I have a life. All those things sound like very good advice to me.
So I didn't miss anything?
I think you got all the. I think
you
hit
really
all the,
want me to say?
No, you hit all
maybe they'll take it seriously if it comes from a Supreme Court justice.
I know I do. Okay, so I think we have time for a couple of questions. Is there anybody who? Yes.
Hi, I'm Sorry, I snuck in
Why
on
are
the
you
1-0
here?
event. Because you're here.
No, but I was here like last year.
We had...
Okay,
Anyways, you're better. You mentioned earlier that sometimes you get cases that you think are going to have a big impact on the law or on the country or the world. And in law school, we're taught actually not to think about the potential impact, but to focus exclusively on the legal issues and applying the law to the facts. So I'm curious how much your perspective on what's going on in the world or the country actually informs the way that you analyze and ultimately decide cases.
Well, I guess I wonder why you think that that's true of what. But here's what I loved about law school. So I'll start there, because in terms of how you should be thinking about this experience, what I loved about law school, what made me really want to go to law school, and what I loved when I was here, was that on the one hand, it was just sort of extremely challenging and interesting and fun as a kind of abstract enterprise. Like, it was a lot of law school was sort of, if you like doing puzzles, and if you just like thinking through things, and this sort of quest for the best solutions to problems is challenging and engaging all on its own, without thinking about how they matter in the world. And that was true for me then, and it's true for me now, that there's some aspect of law that's just, to me, very engaging and very personally engaging and challenging, without thinking about what impact the answers might have. But the reason I came to law school, I mean, you can find challenging questions in many different fields, and for me, I was trying to figure out whether I wanted to go be a historian or I wanted to go to law school. And one of the reasons that I picked law school was because it also mattered. It wasn't just a kind of let's solve a puzzle today. It was a way to think about how you can improve your community, your country, the world in any of a number of respects that you might care about. And I think that that's an incredibly important thing to think about during law school. Is that, hopefully you find the whole experience of reading cases and thinking about cases engaging. But it's also, you're learning skills, and you're learning subject matter areas that you can then put to use for whatever you think are good purposes in your community, in your country. I think, I guess I hope law school doesn't sort of suggest that you shouldn't think about those things. To me, that's a big part of what makes law school so interesting, and what makes this law school so interesting, I will say, is that there are so many opportunities here to actually take all these skills and to take all this knowledge that you learn in your first year and then on into your second and third year, and to use them for purposes that you really care deeply about.
Yes, that is a big thing that we do. Yes, I agree. Other questions? Yes, over there.
Hi, I'm Michelle. I'm from the Graduate School of Education. Sandra Day O'Connor said that she didn't define herself as a feminist. And I was wondering how you felt about that term, and whether or not being in this role has changed the way you view being a woman in America.
Well, I think I've always thought of myself as a feminist, but then again, I guess I don't really think that the label means, different people use labels in different ways, so I'm not sure it means all that much. So let me just talk about what it means to be a woman on the court, which is maybe more, I don't know, it's more interesting to me. And how that makes a difference, and whether it makes a difference. And I think it does make a difference, but not in the way that you might expect. So I think that, lots of people think it's good to have women on the court because they'll bring a whole different perspective to the law, and our cases will be decided differently. And I think that's. I'm not saying that never happens, but it's not all that often that I think that the experiences of women as women and men as men, really decide cases. I think that there are women who think lots of different things, and there are men who think lots of different things. And I very rarely, I'm not sure in my time at the court I ever can think of a case where I felt as though certain experiences that of women really made the difference in a case. Although obviously whenever any person decides a case, they decide a case with some, all of their experiences, including the ones that are gendered, go into that. But I think deciding cases is a much more complicated thing than it's like, well, the men would do it this way and the women would do it that way. But I do think it's important to have women in the court system, and the more the better. We're now 3 of 9. My colleague Ruth Bader Ginsburg said, what's the matter with 9 of 9? But I think that it's important because people relate to institutions in different ways. When the institution has people who look like you on it, and so that might be more women, it might be more ethnic and racial diversity, it might be, you guys don't think about this, I'll tell you this, but when I go to other law schools, the only thing that they want to know is why does the Supreme Court only have Harvard and Yale graduates on it, and how about us? And that's a very meaningful question to law students in pretty much every law school except for 2 of them. And I think people's ability to look at an institution and say that there are people like me on it, even if that doesn't translate in any very direct way to particular decisions, is a pretty important thing in a society. And sometimes I look out at the audience in arguments, and there are very, very often school groups, so elementary school kids and high school kids, and they're seeing a court with 3 women on it, and the way we sit on the bench, Justice Ginsburg is kind of in the middle because of her seniority, and Justice Sotomayor and I were on the 2 ends until just recently when Justice Gorsuch came on, and none of us are shrinking violets. We're all pretty assertive at oral argument, and just when I would sort of look out into the audience, I would think all these girls and all these boys are seeing a bunch of women who are playing a really active, engaged role in this important governmental institution, and that's a great thing. So it just, so I think people, when they focus on exactly how does it matter around the conference table, and what decisions would you have made differently if you didn't have the experiences that you did as a woman, are focusing on the wrong thing. That the important thing is how the institution looks and how people can relate to it. And for that, I think diversity matters a lot.
Fantastic. Thank you so much for your friendship, your generosity, your openness. This was really, really interesting. Let's all thank Justice Kagan.
Thank you. Thanks a lot, everybody.